What to do if pressured in family law arbitration. Imagine sitting in an arbitration hearing, feeling pushed to agree to something you're uncomfortable with. It can be confusing and stressful, but knowing what steps to take can protect your rights. Arbitration in family law is meant to be a voluntary process where both sides agree to resolve disputes with the help of a neutral third person called an arbitrator. If you feel pressured, it could threaten the fairness of the process and the validity of the outcome. First, take a moment to pause and understand what kind of pressure you are experiencing. Are you being pushed to accept a deal quickly? Is someone trying to intimidate you into agreeing? Recognizing the source and nature of the pressure helps you decide your next move. It might be coming from the other party, their lawyer, or even the arbitrator if they seem to be rushing you. Next, communicate your concerns. If you are self-represented, tell the arbitrator directly that you feel uncomfortable or coerced. If you have a lawyer, discuss your feelings with them immediately. Arbitrators are expected to ensure that both parties participate voluntarily and fairly. They should intervene if they notice undue pressure. It's also wise to review your arbitration agreement. This document explains the rules and procedures of your dispute resolution process. Check if it mentions how to handle unfair treatment or pressure. Knowing your rights under the agreement can give you grounds to raise concerns formally. If you feel pressured during a hearing, ask for a break or an adjournment. Use this time to speak with your lawyer or gather your thoughts. You can request a pause to ensure you are making decisions freely and with full understanding. Remember, arbitration hearings are less formal than court trials but still requiring voluntary participation. Keep a detailed record of any instances where you feel pressured. Write down what was said, who was involved, and when it happened. This documentation can be useful if you decide to challenge the arbitration decision later or seek court intervention. Understand that arbitration awards are usually final and binding. However, if you believe the process was unfair due to coercion or misconduct, you might have grounds to challenge the award in court. Grounds include fraud, serious procedural unfairness, or if the pressure amounted to coercion that affected your ability to participate. If arbitration feels too adversarial or you continue to feel pressured, consider other options. Mediation involves a neutral mediator helping both sides negotiate without making decisions for you. Traditional court proceedings are another route if you believe the arbitration process is not working fairly. Remember, the goal of family law arbitration is to resolve disputes efficiently while respecting everyone's rights. Feeling pressured signals that the process may not be proceeding properly. Acting quickly by voicing your concerns, seeking legal help, and understanding your rights can help protect your interests and keep the process fair.